Please be seated. The sitting is open. I'd like to note that today the following judges are present with me in the Great Hall of Justice. Vice President Gevorgyan, Judges Tomka, Yusuf, Sebutende, Iwasawa, Nolte, and Charlesworth, and Judges Adhoc, Pillay, and Kress, whereas Judges Abraham, Benuna, Shui, Bandari, Robinson, and Salam are participating by video link. The court meets this afternoon to hear Myanmar's second round of oral argument. I shall now give the floor to Mr. Christopher Staker. You have the floor, sir.
Madam President, Mr. Vice President, members of the court. The parties were reminded at the end of the first round that there's no need in the second round to repeat any statements already made. In this second round, I will present arguments in respect of the first and fourth preliminary objections. Professor Tauman will then address the second preliminary objection, followed by Professor Kolb, who will deal with the third. The agent for the Republic of the Union of Myanmar will then close Myanmar's second round. However, before turning to the individual preliminary objections, I will first address three general matters arising out of the Gambia's first round of oral argument. The first matter is this. The Gambia acknowledged several times during the first round that the Provisional Measures Order considered issues of jurisdiction and admissibility only on a prima facie basis. That is correct. In that order, the court expressly observes that at the provisional measures stage, it need not satisfy itself in a definitive manner that it has jurisdiction as regards the merits of the case. Issues of admissibility are dealt with in the order on the same prima facie basis. Thus, paragraph 85 of the Provisional Measures Order states unequivocally that the order in no way prejudges the question of the jurisdiction of the court and admissibility of the application, and that the order leaves unaffected the right of Myanmar to submit arguments and evidence in respect of those questions. The court itself thereby clearly acknowledges the right of Myanmar to request that the same issues of jurisdiction and admissibility be determined on a definitive basis at a subsequent preliminary objections phase. Despite this clear intention, this clear indication from the court, statements were made by the Gambia in the first round suggesting that the four preliminary objections have somehow already been decided by the court at the provisional measures stage, and that the court's decision should not change given that nothing has changed in the meantime. However, if the preliminary objections have not been prejudged in any way, as paragraph 85 of the Provisional Measures Order makes clear, then in the present phase of the proceedings, the preliminary objections must be subject to a full de novo consideration in the light of the comprehensive evidence and arguments of the parties. Not only is the Provisional Measures Order not decisive, it is not even a starting point. At this stage, it is no longer material at all to the particular issues now under consideration. The second matter is this. The preliminary objections are entirely independent of the merits of the case. Despite this, during the first round, counsel for the Gambia have made various statements which pertain to the Gambia's substantive claim in the case, or pertain to claims of other events in Myanmar unrelated to the preliminary objections. These statements of the Gambia obviously call for no reply at all in the context of the present hearing, which is confined to the preliminary objections. And Myanmar's failure to address these statements cannot be considered as any kind of concession. The third matter is this. The preliminary objections fall to be decided in accordance with the law governing the jurisdiction of the court and the admissibility of cases. This is so self-evident that it should not need to be stated. However, I do state it because the Gambia has made statements that possibly imply otherwise. During the first round, the Gambia made statements to the effect, for instance, that only the court has any influence over Myanmar, that if the court does not exercise jurisdiction, Myanmar will be accountable to no one, that maintaining the existing provisional measures is essential, that the court bears a responsibility for upholding the Genocide Convention, and that the preliminary objections are in conflict with the aims of that convention. Given that the preliminary objections are independent of the merits, it is difficult to see why these statements were made by the Gambia at this stage. Unless the Gambia is suggesting that the court should modify the law of jurisdiction and admissibility in its application to this case because of these contended matters. It is apparently suggested that in the case of the Genocide Convention, preliminary objections should be regarded as concocted technicalities. Any such suggestion, if it is being made, should not be accepted. The court cannot, in any individual case, expand its jurisdiction or expand the scope of admissibility of cases simply because it is persuaded that it has a useful role to play in a particular situation. These statements of the Gambia are therefore not relevant to this hearing, and counsel for Myanmar need not address them. The written preliminary objections acknowledge the importance of the Genocide Convention. However, no matter how important it may be, it remains subject to general rules of international law governing the jurisdiction of the court and the admissibility of cases, as well as, for instance, rules relating to reservations to treaties. It is trite law that the court does not have jurisdiction over every alleged breach of international law by every state in every situation. What the court must determine is whether, as a matter of law, it has jurisdiction and whether the case is admissible, not whether it would be desirable for that to be the case. Madam President, members of the court, with that, I turn to the first preliminary objection. As I noted in the first round, this involves a main question of fact and a main question of law. As to the question of fact, in the first round, the Gambia provided no further particulars of its dealings with the OIC and other member states, and certainly no further evidence of these matters. It did, however, make certain further general statements, unsupported by evidence, such as that the Gambia assumed a leadership role, and that it was the Gambia that conceived of the idea of bringing this case. These statements cannot be treated as facts or evidence. The Gambia refers dismissively to the evidence before the court as an eclectic variety of websites, articles, tweets, and press releases. However, key items of this evidence are material issued by the OIC, the United Nations, the government of the Gambia or its representatives, and other OIC member states, as well as media reports of statements of governments. It remains the case that the Gambia has not denied the specific contents of any of this material. Indeed, the Gambia has now expressly confirmed that its decision to bring this case was taken by its cabinet only in July 2019, at which time the cabinet endorsed a proposal by the OIC. The Gambia has also not denied, and indeed has implicitly accepted, the evidence relating to the funding arrangements for this case. The Gambia says that Myanmar has glided over the evidence that matters. This evidence that matters is said to include the opening statement of the Gambia's agent at the Provisional Measures hearing. However, the agent was not appearing as a witness, and that opening statement cannot be treated as evidence. In any event, that opening statement gives no additional particulars of the dealings between the Gambia and the OIC and its other member states leading up to these proceedings. It merely describes a visit that the agent made to camps in Bangladesh in early 2018 as part of an OIC delegation. The only other evidence that matters, identified by the Gambia, are the 25 September 2018 statement of the President of the Gambia to the General Assembly and the 11 October 2019 note verbale. The Gambia appears to argue that this evidence shows that the Gambia took actions itself, acting in its own name, and doing so voluntarily. However, that is not to the point. In any case where a state acts on behalf of a third state as a proxy, the proxy will typically itself undertake the relevant actions in its own name and will invariably do so voluntarily. There may be any number of reasons why it agrees voluntarily to act on behalf of a third state as a proxy, But as the Gambia says, motivation is irrelevant to issues of jurisdiction. The question is therefore not whether the applicant state is voluntarily undertaking actions itself in its own name. The question is rather whether the voluntary actions that it is undertaking itself in its own name are in fact being undertaken on behalf of a third state as the third state's proxy. That is a question of fact to be decided on the evidence. In short, the Gambia's first round arguments take the facts no further. The state of the evidence before the court is the same as it was before the first round. Contrary to what the Gambia suggests, it is not Myanmar's case that the Gambia is the real applicant by reason alone that it receives support from others. Myanmar contends that the OIC is the real applicant by virtue of all of the circumstances that have previously been set out by Myanmar. I do not repeat all the details, but essentially, the evidence shows that the proposal to bring this case was made by the OIC committee and endorsed by the OIC Council of Foreign Ministers, after which the Islamic Summit decided that the OIC committee should bring the case on behalf of the OIC. It was only afterwards that the OIC then proposed to the Gambia that the Gambia be the applicant state, and the Gambia agreed. That looks more like the Gambia providing assistance to the OIC than it looks like the OIC providing assistance to the Gambia. I move on then to the question of law. It is common ground that the issue of proxy states has never arisen before. There are 2 points I make in reply. First, contrary to what the Gambia suggests, Article 35, paragraph 1 of the statute is not fatal to Myanmar's argument. It has no impact on Myanmar's arguments at all. This provision states that the court shall be open to the states parties to the present statute. Apart from anything else, this does not in any way qualify or create an exception to Article 34, paragraph 1, which provides that only states may be parties in cases before the court. Additionally, Article 35, paragraph 1 does not suggest that the court is open to international organisations or other entities that are not states. Furthermore, the mere fact that a state is a party to the statute of the court and that the court is therefore open to it, pursuant to Article 35, paragraph 1, does not mean that the court will have jurisdiction over any case brought by that state, or that any case brought by that state will be admissible. The arguments previously presented in relation to Article 34, paragraph 1, apply equally to Article 35, paragraph 1, and the latter provision takes matters no further. The academic texts relied on by the Gambia in this respect were not addressing the issue now before the court and are not inconsistent with Myanmar's arguments. Secondly, the Gambia conflates two separate issues, namely the motivation of a state for bringing proceedings and the question of whether the applicant state is in fact bringing proceedings on behalf of another state or entity. The Gambia argues that if the applicant brings proceedings because another state or entity wants it to, that is simply the applicant state's motivation for doing so, and that motivation is irrelevant to jurisdiction. This is incorrect. I will not repeat arguments I have already made, indicating how the use of proxy states by states and other entities not entitled to bring a case would be contrary to principles of reciprocity, good faith, and effectiveness. The bringing of a case as proxy for a third party engages principles and issues going well beyond the principle that motivation is irrelevant to jurisdiction. This distinction is far from artificial. Madam President, members of the Court, I move on to the fourth preliminary objection. As to the legal principles, Myanmar has not abandoned anything stated in the written preliminary objections. I note that some of the definitions of dispute found in the case law may in fact be worded somewhat too broadly to reflect the actual principles applicable to determine if there is a dispute. Myanmar contends that the correct principles are those set out in its pleadings and oral argument. I have already explained why the requirement for both parties to be aware of the other's position is reflected in the Marshall Islands cases. I have also already explained why, contrary to what is claimed by the Gambia, this requirement would not give the respondent a silent veto over the bringing of cases before this court. Contrary to what the Gambia suggests, I did not say that the parties must enter into negotiations before a case is brought before the court. Rather, I said that both parties must be aware of the other's position. Two parties can be aware of each other's opposing positions without any negotiations between them taking place or having yet taken place. And indeed, this will be a common situation. I did not say that the parties must attempt friendly settlement before going to court. Rather, I said that because the court is an alternative to the direct and friendly settlement of disputes, there will not be a dispute for purposes of court proceedings unless there is a dispute that could be the subject of friendly settlement. And for this, both parties would need to be aware of the other's views. Contrary to what the Gambia suggests, I did not say that an applicant must articulate its claims in such detail that it would effectively have to share a draft of the application with the potential respondent. Rather, I made clear that only a minimum degree of particularity is required. Contrary to what the Gambia apparently seems to suggest, the court's case law does not indicate that there is any defined time after which silence by a respondent can be treated as positive opposition. Clearly, the question whether a response is called for at all will depend on the individual facts of a particular case. If it is, the maximum reasonable length of time for a response will also vary, depending on the circumstances of the particular case. I did not say that Myanmar was entitled to an indefinite or unlimited amount of time to respond. I said that the note verbale did not call for a response at all, but that even if it did, a reasonable time for a response would have been more than a month. For the reasons given in the written and oral arguments, matters relied on by the Gambia as establishing the existence of a dispute, apart from the 11 October 29 note verbale, could not possibly establish the existence of a dispute. As to the note verbale, it is indeed correct that the note verbale did not state any facts. It merely referred to the findings in the FFM report and to an OIC resolution. It is also correct that there is no suggestion that the Gambia had access to the fact-finding mission's primary evidence on which the report was based, such as the witness interviews that it took. For all the reasons given in the earlier written and oral arguments, this note verbale was not a legal claim that called for a response. And the mere fact that the Gambia announced in the General Assembly on 26 October 2019, prior to sending the note verbale on 11 October 2019, that it intended to bring a case before this court, does not mean that the note verbale should be considered to satisfy the prior dispute requirement if it otherwise would not. Indeed, once the Gambia announced publicly on 26 September 2019 that it intended to bring a case before this court, the failure of the note verbale to mention this intention gave rise to an even stronger inference that it was not a document that itself was raising a legal claim. Since after 26 September 2019, there would have been an even stronger expectation that the note verbale would refer to this intention if it was indeed a legal claim. Madam President, members of the Court, that concludes my arguments on the first and fourth preliminary objections. I would now invite you, Madam President, to call on Professor Talman to address the second preliminary objection.
I thank Mr. Staker, and I now invite the next speaker, Mr. Stefan Talman, to take the floor. You have the floor, Professor.
Madam President, Mr. Vice President, distinguished members of the Court. My task today is to respond to the Gambia's observations made in reply to Myanmar's second preliminary objection that the Gambia lacks standing in this case. On Wednesday, you heard that Myanmar's argument was absurd, abject, ahistorical, erroneous, tenuous, concocted, and unfortunate. What you did not hear was any positive argument that the Gambia does have standing in the present proceedings. Let me start by saying that the Gambia, in its oral presentation, as in its written observations, constantly and consistently conflates, or better mixes up, the invocation of responsibility and the standing of a state in proceedings before this court. For example, the Gambia speaks of standing to invoke the responsibility of the perpetrator of genocidal violence. Let me be clear. The invocation of responsibility and standing are two distinct concepts. The ILC expressly noted this in its commentary on the Articles on State Responsibility, which I quoted on Monday. Myanmar addresses the question of the invocation of responsibility only because the Gambia erroneously equates a right to invoke the responsibility of a state with standing before this court, and draws the conclusion that whenever there is a right to invoke the responsibility of a state, there must automatically be standing. This simply is not the case. But let me address the Gambia's argument with regard to the invocation of responsibility. First, contrary to the Gambia's assertion, Myanmar has not accepted that the Gambia could invoke its international responsibility in the present case. No such admission was made, and no such conclusion can be drawn from the court's finding in its provisional measures order that Myanmar accepts that the Gambia has an interest in Myanmar's compliance with erga omnes partes obligations. Second, and more importantly, the Gambia cannot invoke Myanmar's responsibility with regard to alleged acts of genocide committed against non-nationals outside its own territory because of the nationality of claims rule. The Gambia cannot and has not explained away Article 44, subparagraph A of the Articles on State Responsibility, which provides, and I quote, "The responsibility of a state may not be invoked if the claim is not brought in accordance with any applicable rule relating to the nationality of claims." End of quote. The text is clear and unequivocal, and so is the ILC's commentary. There is no exception to the nationality of claims rule for certain treaties or certain types of obligations. The Gambia seizes on the phrase "any applicable rule relating to the nationality of claims" and a statement in the commentary that the rule of nationality of claims is a general condition for the invocation of responsibility in cases where it is applicable. Let me first highlight that the ILC itself calls the nationality of claims rule a general condition for the invocation of responsibility. So the nationality of claims requirement is the rule, not an exception, in all cases in which it is applicable. It is correct that the nationality of claims rule is not applicable in all cases of state responsibility. But it is applicable in all cases in which a state invokes the responsibility of another state for an injury caused by an internationally wrongful act of that state to a natural or legal person. Thus, the rule is clearly applicable in the present case. The Gambia invokes the responsibility of Myanmar not for its own injuries, but for injuries allegedly caused to individuals in Myanmar's northern Rakhine state. So, what arguments has the Gambia put before you for its contention that in the case of the Genocide Convention, the nationality of claims rule is not applicable? First, it argued that, I quote, "Nothing in the Convention suggests that it would be," end of quote. But one must ask, must there be an indication or even express provision in the Convention on the application of the nationality of claims rule? The short answer is no. The Genocide Convention deals with primary obligations. The nationality of claims rule in the context of state responsibility is a secondary rule. It deals with the general conditions under international law for a state to be considered responsible. These secondary rules apply to all treaties, so there is no need to deal with these general conditions in each and every treaty. The Gambia has not provided any example of a treaty that indicates or expressly provides for such application. The reason is simple. There is none. The application of the nationality of claims rule does not depend on the treaty, but on whether injuries have been caused to individuals. The Gambia, secondly, advances that the application of the nationality of claims rule in the case of the Genocide Convention, and I quote again, would be contrary to the object and purpose of the Convention, end of quote. However, the Gambia does not explain why the application of a general secondary rule would be contrary to the Convention's object and purpose. First of all, the Gambia does not clarify the object and purpose of the Convention, but simply states that genocide is contrary to the spirit and purpose of the United Nations, and that it shocks the conscience of mankind. This says nothing about the object and purpose of the Convention, and why a general secondary rule of international law should not be applicable in the present case. It is submitted that the object and purpose of the Convention is, to quote the Court's own words, to condemn and punish genocide as a crime under international law, by establishing individual criminal responsibility for acts of genocide and to bring the perpetrators of such acts to justice. The Convention must be seen against the background of the Nuremberg and Tokyo war crimes trials, and not against any interstate claims before this Court. As the tribunal at Nuremberg held, crimes against international law are committed by men, not abstract entities. Myanmar's argument is thus by no means ahistorical. The object and purpose of the Convention does not demand that any contracting state can invoke the responsibility of every other contracting state with regard to alleged acts of genocide committed against non-nationals outside its territory. If the nationality of claims rule were in fact contrary to the object and purpose of the Convention, one may ask why reservations to Articles 8 and 9 of the Convention should not also be contrary to the Convention's object and purpose. They too prevent contracting states from bringing alleged acts of genocide before this court. The application of the nationality of claims rule to the invocation of responsibility in case of injury to individuals may, in the words of the Gambia, lead to unfortunate results. But the Gambia has not presented any convincing argument why it should not be applicable in the present case. The nationality of claims rule precludes the Gambia from invoking Myanmar's responsibility with regard to alleged acts of genocide committed against persons who are not its nationals. Thus, even if the invocation of responsibility had any bearing on the question of standing, which it has not, this could not establish standing in the present case. Madam President, members of the Court, the Gambia asserts that in case of the Genocide Convention, standing does not require an individual legal interest, but that a common interest in compliance with the Convention is sufficient. It is correct that the Court held in its Provisional Measures Order that all states parties to the Genocide Convention had such an interest, and on that basis found that the Gambia has prima facie standing to submit to it the dispute with Myanmar. The Court reached this decision on the basis of its findings in Belgium versus Senegal, which, as I have demonstrated on Monday, can be distinguished both on grounds of fact and law. I would also like to reiterate the Court's own statement in paragraph 85 of the Provisional Measures Order that, I quote, "The decision given in the present proceedings in no way prejudges any questions relating to the admissibility of the application. It leaves unaffected the right of the parties to submit arguments and evidence in respect of those questions." End of quote. As the Gambia has noted, new argument has been submitted at this hearing on the admissibility of claims, which in Myanmar's view shows that the Gambia lacks standing in the present case. If I may add, this would not be the first case where the Court decided at the provisional measure stage on a prima facie basis that it had jurisdiction or a claim was admissible, only to hold later that it was without jurisdiction or the claim was inadmissible. It is thus far-fetched to assert that by welcoming the Provisional Measures Order, the United Nations General Assembly and the member states confirmed that they do consider the Gambia's standing to be established. There is no support for this assertion. Madam President, the Gambia tries to dismiss Myanmar's argument based on paragraph 91 of the court's judgment in Barcelona Traction, because the paragraph does not expressly mention the Genocide Convention. This paragraph, however, deals with the general question of standing in case of violations of obligations erga omnes, taking such obligations under universal human rights instruments only as an example. The court held that the erga omnes partes character of these obligations have been established to protect a common interest. But it has also held that these instruments, and I quote, do not confer on states the capacity to protect the victims of infringements of such rights, irrespective of their nationality. End of quote. The question may thus be asked why the nationality of claims rule is applicable to obligations erga omnes partes in universal human rights instruments, but should not be applicable in the same such obligations in the Genocide Convention. The Gambia has offered no answer to this question. In the Barcelona Traction case, the court contrasted the situation under universal human rights instruments with the situation under the European Convention on Human Rights, another treaty established to protect the common interest of all states parties. The European Convention, in its Article 33, expressly vests a right in all contracting states to refer any alleged breach of the Convention to the European Court of Human Rights. This shows that, absent an express authorization of standing, the mere fact that a treaty is established to protect the common interest does not suffice to establish the standing of all contracting states in any given case. The Gambia also seeks to dismiss the court's finding in paragraph 185 of the Bosnian genocide case that a claim with regard to non-nationals could raise questions about the legal interest or standing of the applicant. For the Gambia, this passage is irrelevant because the court did not decide these questions. But this misses the point. The fact that the court felt it necessary to raise the question shows that the finding of a common interest of the parties of the Genocide Convention does not settle the question of standing. Madam President, members of the court, let me now turn to the Gambia's novel definition of standing. While the court has defined standing as legal right or interest regarding the subject matter of a party's claim, the Gambia now offers you a new definition. Standing now supposedly requires, and I quote, nothing more than the interest in respecting the rules at the heart of the dispute, end of quote. This new definition calls for several observations. First, this is a purely results-driven definition. A new definition has been constructed only to prove that the requirements of the new definition are met in the present case. Second, the case of the SS Wimbledon is a bad starting point for any new general definition of standing. Standing in that case was based on Article 386, paragraph 1 of the Versailles Peace Treaty, which provided that in the event of violation of certain provisions of the treaty, any interested party could bring the case before the Permanent Court of International Justice. Article 386, like Article 33 of the European Convention on Human Rights, thus provided an exceptional authorization of standing. Third, there is no support for this new definition in the jurisprudence of the Court. On the contrary, the Court still uses the terms standing and legal interest interchangeably, as shown in the Bosnian genocide case. Madam President, members of the Court, let me conclude again with a general observation. Listening to the Gambia's conclusions on Wednesday and its assertion that it has standing to bring this case against Myanmar because any other finding would seriously undermine the value of the Convention, reminded me of a line in the poem The Impossible Fact by German poet Christian Morgenstern. For, he reasoned pointedly, that which must not, cannot be. But this is not the reasoning you are supposed to apply in this court. Myanmar therefore invites the court to find, in accordance with the established law on the admissibility of claims, that the Gambia lacks standing in the present case and that, accordingly, its application be dismissed as inadmissible. I thank the Court for its kind attention. Madam President, may I now ask you to call on Professor Kolb to present Myanmar's third preliminary objection.
I thank Professor Tallman. I now give the floor to Professor Robert Kolb. You have the floor, Professor.
Madam President, members of the Court, I'd like to return to my arguments on the third preliminary objection. I have listened carefully to my opponents, but I must confess that I'm not entirely satisfied with their interpretation of Article 8. Let us face the facts. I will do so first by looking at our question through the lens of Article 8. Then I will examine it again from the perspective of the reservation The two lenses are not identical, and therefore what is observed is different depending on the reference point that is chosen. If Article 8 does not concern the seizing of the United Nations organs, what can possibly be the meaning of Myanmar's reservation? Let's be honest. The reservation would fall into legal limbo. Would Burma have made a reservation that has no effect from a legal point of view? Wouldn't that be absurd and unreasonable? If a state takes such care to enter a reservation to provision in such an important treaty, it certainly aims to achieve legal effect. But then it is told that its act was gratuitous, senseless, Kafkaesque. I simply cannot resign myself to accepting that. Let us assume that Article 8 concerns only the political organs of the World Organization. Assuming that it affects their seizing, we are still faced with the same legal situation. The political bodies can be seized depending on the relevant provisions of the Charter, such as Articles 35 and 39. It would be unreasonable to claim that the reservation to Article 8 of the 1948 Convention could impact the jurisdiction of these organs under the Charter. If so, it would still be possible to argue that their seizing for questions related to the interpretation or the application of the Convention would be impossible. But such a limitation would carry no tangible weight. The seizing could concern genocide as a threat to peace or as a violation of human rights. The reservation would not apply. Therefore, it would have no useful effect in the field of political bodies. Even more so if Article 8 doesn't concern seizing. In this case, the reservation would merely float in legal weightlessness. Let us now assume that Article 8 also concerns the court. If it does not regulate the seizing of the court, but leaves that to Article 9, once again, Myanmar's reservation to Article 8 has no effect whatsoever. The court would be seized on the basis of Article 9 and have jurisdiction. I would like to draw the following conclusions from what I have said before. My first hypothesis is as follows. Let us assume that Article 8 does not cover the seizing of the organs referred to, but merely recalls the reserving state is crucial to the interpretation of reservations. The second hypothesis is as follows. Article 8 concerns only the seizing of political bodies. However, this seizing cannot be prevented by entering a reservation. This reservation does not extend to the relevant provisions of the Charter. Yet again, the reservation would have no effect. Third hypothesis, that Article 8 concerns the seizing of both political and judicial organs. However, the seizing of the court is regulated solely by Article 9. For the umpteenth time, the reservation to Article 8 would be pointless, have no effect, and no reality, because the political bodies can be seized based on the provisions of the Charter. In this hypothesis, and the court can be seized on the basis of Article 9. Therefore, I dare present a fourth hypothesis, that Article 8 concerns the seisin of the court. The reservation now rises from the ashes, and its effect of not allowing the seisin of the court. This is the only way in which the reservation can have a useful effect. It is the only way to respect the will of the reserving state. Let us now reverse the perspective and place ourselves in Burma's optical field. It is this shift in relativity that I was announcing at the beginning of my pleading. If the state had doubts as to the fact that its reservation could prevent the seisin of the court, wouldn't it have entered it to Article 9, just like many other states did? However, if Burma indeed considered that its reservation to Article 8 would prevent the seisin of all UN organs, it becomes easy to understand why it didn't enter a reservation to Article 9. Otherwise, it is not understandable. One hesitates and slips in more or less discreetly. Why didn't you do so? With a slight hint of reproach. Well, the explanation is fairly straightforward, and it is that from Burma's perspective, a reservation to Article 9 was no longer necessary. Burma believed that it had already ruled out any seisin of a UN organ that might interfere in its internal affairs. There is a very important aspect here that I wish to draw your attention to. What is essential in this case is to make sense of Burma's reservation. What could it mean? How should it be understood? The perspective is decidedly subjective. It is the intent and purpose that Burma had in mind that needs to be scrutinized so as to make reliable sense of its reservation. If this is done, then the objective interpretation of the relationship between Articles 8 and 9 of the Genocide Convention is not decisive. Even if our opponents were right and Article 8 were objectively irrelevant to the court, the fact remains that one must pay attention to Burma's representations in order to understand the meaning of its reservation. It is important to look at Burma's understanding of these provisions and their relationship with each other. If we do so, there can be no possible doubt. If Burma had not believed that Article 8 related to seisin, its reservation would have had no useful meaning. Let me switch perspectives again. We have the case here of a state entering a reservation that it deems absolutely necessary to a provision that it considers important in a major treaty. Distinguished members of the court, you are nationals of very different states yourselves. You are aware of the reservations that your states thought it necessary to enter in this or that treaty that they deemed important. You know how emphatic they can be about it. And now our opponents are asking this court to ignore such a reservation. They're asking it to act as if it didn't exist. What message would the court send out to states that are following its jurisprudence so carefully that the court doesn't take their reservations seriously? That it allows itself to gloss over them because they're trivial? That these meticulously crafted reservations can in one fell swoop fall into oblivion? Indeed, from an ideal point of view, we can all admit that reservations unfortunately erode the integrity of texts. However, it is not our task to ignore them merely because they don't suit us. Finally, I would like to draw the attention of the court to a paradox in our opponent's reasoning. If Article 8 indeed concerns the season of political organs, and the reservation does have effect in this respect, it would mean that season of political organs would be barred, but not the season of the court, which would be preserved by Article 9. The consequence of this would be that Myanmar would be protected from the season of organs that only issue recommendations most of the time, but it would not be protected against the season of an organ whose decisions are binding on it. That would be a strange effect for a state trying to shield itself from outside interference. Minor interference would be impeded, but major interference would be allowed. I find it hard to believe that such an effect can be easily reconciled with the intention of the reserving state in this case. Therefore, the interpretation of Article 8 that covers the court seems more coherent if one takes into account the purpose of this reservation.
I have just expressed our main problem, the main problem that I run up against. Can we really, at the stroke of a pen, remove all legal effort or effect from the reservation expressed by Burma and turn it into a legal zombie, even more, to nullify it? Madam President, distinguished members of the bench, I would not like to speculate on your feelings, but I must admit that I, at least, would have some difficulty in concluding so. Nothingness is a concept which is interesting in philosophy. I don't believe that it is so as regards the world of reservations against treaties. We cannot adopt a solution which would be tantamount to completely ignoring the reservation that Burma had attached to Article 8. This reservation is there, and it must be given a meaning. I'll now turn to three arguments advanced by our opponents. Time is too short to run through them all. I don't think it useful to keep you spellbound with detailed explanations, tedious in their technicity, and useless as regards the information already assembled in our pleadings. The first argument: the distinction between injured states and non-injured states does not allegedly fit with the texts. Our opponents have stressed that Opponent 8 would not support it. It is apparently true of the travaux préparatoires of this provision. And I agree. I personally was referring not to Article 8, but to the reservation. Does this text of the reservation allow for such a distinction? To surprise you, perhaps, my answer would be no. The reservation excludes every application of Article 8 from the scope of acceptance of Burma. It draws no distinction between the injured state or the non-injured state. But where does this distinction come from? It arises thanks to a generous gesture made by Myanmar. Myanmar would be entitled to count on the exclusion of all seizin by basing itself on the implacable text of its reservation. But it didn't want to go that far. It preferred to limit the extent of its reservation to seizin only by non-injured states. Without doubt, it would have been easier if it hadn't done so. But can one really reproach Myanmar for wanting to soften the rigor of its reservation? If our opponents would prefer to stick just to the text of this reservation, then the legal answer, within the viewpoint of Burmese intention, is simple and straightforward. Every seizin, whatever, is excluded, whether it comes from an injured state or a non-injured state. I can leave it at that, because this distinction does not seem to me to be so important so as to solve the current case. The key point lies elsewhere. It concerns the object and purpose of the reservation, to exclude seizin ending up in interference in internal affairs. The seizin of the court is quite clearly the result of such an interference, particularly so as it ends in a binding decision. If the reservation only covered articles linked to Article 2, Paragraph 7 of the Charter, then it would be a misunderstanding of its wording. Why should one radically exclude the application of Article 8 and not simply limit oneself to reproducing the usual contemporary language about internal affairs? The second argument. Great play has been made of the travaux préparatoires in Articles 8 and 9. Here, this is a series of tortuous facts in a list of positions, sometimes changing, whose interpretation is not so straightforward. It's not suitable material for an oral presentation highlighting the most salient facts. I'll allow myself, therefore, to refer you in this respect to our written pleadings. My aim was to draw your attention to the fact that the limitation of Article 8 to the sole political organs, which are the General Assembly and the Security Council, was rejected in favor of a broader approach, summed up in the words, organs of the United States, the United Nations. There is another reason why I didn't insist on the travaux préparatoires. The Genocide Convention is a multilateral treaty. The interpretation of this kind of treaty is above all based on its text and on other objective elements. The travaux are just an auxiliary source whose task is to confirm or to clarify a result of interpretation or to deny such a result when it is absurd or unreasonable. Would it be unreasonable to suggest here that the Court is a competent organ of the United Nations? Jurisprudence has focused on this ancillary role of the travaux. If the so-called objective methods win the day, then it would be fitting to apply them to all provisions. One cannot choose deliberately or arbitrarily to apply them only to civilizing provisions whilst leaving them aside for provisions which are more technical in nature. A convention is not a potpourri in which each reader can behave as they will. There is a reason, furthermore, for not to have placed a great deal of stress on the travaux préparatoires. They are secondary in interpreting the meaning of the reservation entered by Burma. What here counts are subjective representations. Consequently, the intention of Burma is capital. I will briefly evoke the travaux so that you don't think that I wish to avoid them because they would not provide enough grist to my mill. I would raise particularly two significant facts. Articles 8 and 9 were negotiated together. They were even merged during one phase of negotiations before again being separated. Article 8 therefore appeared as the general provision, the gateway, if you will, whereas Article 9 detailed the specific nature of aspects of jurisdiction here at the Court. You will not see this watertight separation between the political and legal domains that our opponents have espoused. Furthermore, in November 1948, at a very advanced stage of negotiations, the Treaty of Article 10, now Article 8, used the words "any competent organ of the United Nations." Any competent organ, except the Court? Our opponents have analyzed the meaning of saisir and recourir by stressing their inclusive nature. My opponent has also used the word also to describe the fact that these words apply both to the judicial organs and the political organs of the United Nations. They wanted to support their argument according to which Article 8 only covers the political bodies because the political bodies would not be excluded by the word saisir. But they did not perhaps realize that they had accepted in its wording that this term also included courts. The preparatory work, the travaux préparatoires, concludes some sparse elements supporting this inclusive meaning. If you look at the position taken by Sir Hartley Shawcross on behalf of the United Kingdom, he included in the organs covered by Article 8 the International Criminal Court, as yet uncreated, to punish the crime of genocide. The third argument. Our opponents thought that they had done well to try and trip me up by producing my own articles. But it's a risky bet, because who better than the author knows what he has said? One comment has been quoted against me. It refers to Article 9 of the Convention, and therefore covers the jurisdiction of the Court on the basis of the compromissory clause. I do not withdraw a single word of what I wrote at the time. If there had not been a reservation applicable in the current case, and that we were exclusively based in the hallowed text of Article 9, then the Court would have had this extended jurisdiction that I reported on in my commentary. But I wasn't dealing with Article 8, and certainly not about the reservation expressed by Burma. These questions were out of sight. The academicians amongst you, honoured judges, will understand me easily. I'm sure that the same also applies to those judges deprived of the very relative privilege of having been a professor. Doctrinal documents start from nothing and do not have any fixed guidelines. On the contrary, in a contentious case, you are made aware from the outset of particular or idiosyncratic conditions. They oppose their logic upon you, and I cannot see anything which seems to be a contradiction or an about turn. The context and the underlying logic are not identical. All of this is not the decisive factor in the present case. I didn't really want to raise this point, but nonetheless I was afraid that my silence might have awoken the suspicion of an embarrassment, and I preferred to dispel it. What would I like you to bear in mind above all from my two speeches to you? As follows. Whatever the objectively correct interpretation of the relationship between Articles 8 and 9, can we, in the current case, adopt a definition or an interpretation whose result is to deprive of all legal effect from the reservation expressed by Burma? Your court, well, can it allow itself to ignore completely a reservation which a state has carefully attached to a convention at the moment of accession? This kind of suggestion puts me ill at ease. I'm sure that you will think deeply, and I am in no way afraid of the results that your wisdom will lead you to. These thoughts bring to an end my presentation today. I'd like to thank the Court for its kind attention. And could I ask you, Madam President, to be so kind as to call to the bar the agent of Myanmar for their final conclusions.
I thank Professor Cope, and I shall now give the floor to the agent of Myanmar, His Excellency Mr. Ko Ko Plan. You have the floor, Excellency.
Madam President, distinguished members of the Court, Counsel for Myanmar have dutifully presented their arguments to the Court. As this stage of the proceedings is concerned only with matters of law concerning jurisdiction and the admissibility of the case, that has been our focus. We have refrained from entering into the matters relevant to the merits. Unfortunately, on Wednesday, Counsel for the Gambia made many factual and political allegations that were not relevant to the preliminary objections. The tone of these statements was inappropriate to a court of law at this stage of the proceedings. Myanmar will not respond to these allegations, as now is neither the right place nor time to do so. Will not waste the court's valuable time by making statements not really addressed to the court, but to an audience outside the Great Hall of Justice. In my understanding, these allegations are aimed at intimating to the members of the court and the public that the authorities in Myanmar should be considered perpetrators of genocide even before there has been any decisions on whether there will be a merit phase, let alone any decision by this court. Counsel for the Gambia also appear to suggest that the preliminary objections should not be considered seriously, as the court has already rejected them in the previous provisional measures order. I must respond by emphasizing first that Myanmar is exercising its right as respondent by submitting these preliminary objections as clearly foreseen by paragraph 85 of the provisional measures order. Secondly, a respondent has the right not to be prejudged on the merits at the preliminary objections phase. At any merit phase, the burden of proof will be on the Gambia as applicant to prove its claims. However, it cannot seek to discharge that burden now or speak as if that burden had already been discharged. As of today, the Gambia's claims have neither been admitted to be heard, nor have they been proved, and the Gambia should not act as if it were otherwise. Nevertheless, given that the Gambia have used this hearing as a platform to make allegations about the merits, as agent for Myanmar, I cannot just sit here in silence without responding at all. In my closing remarks, I would like to take just a moment to say that Myanmar is committed to ensuring compliance with the Genocide Convention. For instance, on 25 August 2021, Myanmar amended its penal code and the Code of Criminal Procedure in order to insert additional articles criminalizing genocide and providing for the trial and punishment of perpetrators. Myanmar, as a responsible party, is also implementing its obligations under the Provisional Measures Order. There also are continuous efforts to improve the general situation on the ground. The region now is relatively calm and peaceful without any significant incidents of violence. Before concluding with the reading of Myanmar's final submissions, I would like to thank you all for your careful and patient attention to the arguments presented. I'm very grateful to the registrar and all the staff of the registry who have enabled the smooth and efficient conduct of this hearing, including the interpreters. It now falls to me, in accordance with Article 60, paragraph 2 of the Rules of Court, to read the final submissions of the Republic of the Union of Myanmar. These are as follows. For the reasons given in Myanmar's written preliminary objections and in its oral arguments at the hearing of the preliminary objections, and for any other reasons the court might deem appropriate, Myanmar respectfully request the court to adjudge and declare 1. That the court lacks jurisdiction to hear the case brought by the Gambia against Myanmar, and or 2. That the Gambia's application is inadmissible. Madam President, Mr. Vice President, distinguished members of the court, that concludes the argument of Myanmar at this hearing of the preliminary objections. I thank you.
I thank the agent of Myanmar. The court takes note of the final submissions which you have just read on behalf of Myanmar. Your statement brings to an end Myanmar's second round of oral argument. I recall that on Monday, 28 February 2022, between 3 p.m. and 4:30 p.m., the Gambia will present its second round of oral argument. The sitting is adjourned.